then we cannot have bail. Then we cannot have bail or bond conditions. So people need to be let out immediately, forthwith. They have a lot of information. They are puked with a whole lot of information. The officers do such a fantastic job for the most part in those probable cause statements. Enough where a complaint can be filed. Enough. I can even read this complaint that was filed by the Siren Police Department. There is enough there, right there, enough there that a complaint can be filed. That is forthwith. And all you do is cut and paste and put their complaint into the complaint or their police reports into the complaints anyway. I would not do any bond, zero bond, none bond, because unless it's forthwith within 48 hours, nobody should have their due process rights taken away because we can't get a criminal complaint filed forthwith.
I agree. It is unreasonable for people to be on a cash bond without seeing a court and no
any
complaint.
Bail bond conditions, because right now, this individual, if I have him on bail bond conditions, this individual, and he's not getting a complaint filed a month and 2 days after, why should he risk to have bail bond jump violations when he hasn't even been charged? He doesn't even know if he is going to be charged.
I agree.
So zero bail, zero bond, unless we have a criminal complaint filed forthwith within 48 hours.
I agree.
Done. Then that's what we're going to do. So, Mr. Campo, I'm not sure if you are supposed to have a complaint filed today. I'm hearing no.
Okay.
So you are forthwith discharged from all bail bond conditions. Forthwith. Now.
Really?
Immediately. Cash will be returned to you. And bond gonzo.
Amazing.
Okay. Thank you.
We can have bail conditions set based upon probable cause statements, and the complaints can be filed forthwith. We have the capacity to do that so long as law enforcement knows and they can prepare for it.
All right, forthwith, within 48 hours, I will do bail. Within 48 hours, we will have the initial appearances in every single arrest, every single that comes in front of this court for bail and bond.
Okay. I will speak with law enforcement of what the court's command is. I am going to be gone for the next 2 weeks, so there will be that problem.
Because to me, forthwith does not mean 1 month and 2 days after an arrest. That is not forthwith.
It does not. If there was a bond hearing, I would have told the court to do a signature bond for these.
We will go on the record in the matter 26 GF 133 group file of Brandon Campo. Appearances are we do have appearing in person the district attorney Kevin Schmidt. Mr. Campo appears in person without counsel. We are in victims' rights compliance because the victim is sitting right back there, Ms. Bauer. That is the victim. Look at her face. That is who she is. And so we have Mr. Campo here. This matter, he was brought before the court for the court to put him on a cash bond, a significant cash bond on May 26, 2026. There was enough there for the court to make a probable cause finding because the court does have at least a small police report in this matter. And so he's here. It was scheduled at 1 o'clock, but the man and his wife have walked 2 hours to get here. Correct, Mr. Campo?
That's correct.
You don't have a means of transportation?
No.
And so why are you here at 1 o'clock? Or why are you here now instead of 1 o'clock?
I was trying to get the court date changed because I don't have an attorney.
Because you don't have an attorney, but I understand that, but you don't even have charges filed against you. You understand that part?
So I didn't have to appear?
I would say probably no, because there's nothing filed, but you do have cash, $1,000 cash that was posted based upon a very lengthy probable cause statement with facts enough that you could have been charged or probably should have been charged by now, since it is June 24th. Almost a month past the date. You are dressed very nice for court. Thank you for wearing a shirt and a tie. You look fantastic.
Thank you.
Why don't we have anything charged? Almost 1 month to the day or two late. later.
Because one of the charges lacks probable cause in the police reports.
Then don't charge that charge, but he should be charged by now.
No, because I've asked for police follow-up to find the probable cause for that count.
I thought
Made
you started something in
multiple
Polk County where
requests.
the day that they're arrested, they get probable cause, they get their initial appearance, they have a complaint filed. This should happen here too, because it's almost 1 month since this man was arrested, put on bail with significant cash of $1,000 with bail condition. If there's one count that is not yet enough for probable cause, then you can ask to amend the court. You know the statute, you know the rules. But now we have a man here who he's been under a bail bond condition for almost 1 month with $1,000 cash, and we don't know if there's enough to charge. There's enough at least for probable cause for some of these. You can amend later. You can even amend an information upon preliminary hearing. Right now, this is ridiculous that it's almost 1 month since his arrest, since he was put on cash bail, that he has not been charged.
Judge, we wait for complete reports before filing complaints because our policy is that cases are provable and triable the day we charge them. It's not right now. That is my office's policy.
You can't though,
If
you
the
can't
court-
prove and charge any of these, so you don't want to file anything, because again, discussions of the fact that when you worked at Polk, you developed this system and it's to have all of these things. I don't know if you did that or who did this, but when a man's arrested or a woman's arrested in a lot of counties in the state and per the statute, they are to be immediately provided their criminal complaint. Is it directory? Is it mandatory? Who knows? But in a lot of counties, it happens the day of arrest. And there are amendments to the criminal complaint or amendments to the information. But now it is June 24th. And again, this man was arrested on May 22nd, he was arrested. May 22nd, he was arrested. But the court did place bond and cash on him on May 26th.
Correct. If the court conducted a bond hearing within 72 hours of arrest, I could have told the court of this, but our county doesn't do that.
Our county should do that. Our county should do that, because I guess I'll pull up the statute right now. Because people's rights are restricted. That's why most, or a lot of counties, I can't say most, because we're one of the little counties that apparently don't want to do that. I'm sure you know the statute and you can probably pull it up a lot faster than I can, since that is your job every day. The state must file a complaint without unnecessary delay following arrest, which generally can be interpreted as 48 hours. 48 hours. And that's not just for the court to determine bail, but it should be filed. It should be filed with unnecessary delay. And to this court, this has been beyond an unnecessary delay. When a person is arrested without a warrant and brought before a court, before a judge, a complaint shall be filed forthwith. Forthwith.
This person was never brought before a judge. Bond was set in his absence.
The probable cause was brought before the court with enough information for the court to determine probable cause. So if we're going to start having people arrested and they're going to be brought before the court, then forthwith a complaint will be filed and we will start having bond hearings every single time a person is arrested. This is outrageous. It is completely outrageous.
I would approve of that process. That's why Captain Taggart asked the court to.
Oh,
reset
good.
bond.
Then we're going to start doing that now. And so we will have a complaint filed forthwith at the bail hearing, correct?
We will not.
Then we will not arrest people. Then they will be not arrested and we will not see them, because bail should not be placed on a person unless a person is arrested without a warrant and brought before a judge, which they will be. A complaint shall be filed forthwith. And if other counties, including Polk County, can file it and get it done the day of the arrest, within hours of an arrest, I think Burnett County can do that too.
We will file it forthwith after those bond hearings if the court starts bond hearings.
All right, then I'll do that, and we'll have the bond hearing, and then the very next day we'll have the initial appearance. That was forthwith for the court. So is that what we're going to do, Mr. Schmidt?
I'd have to confer with law enforcement because they have not been consulted with this yet and not been given an opportunity to prepare.
There's enough. Do you understand what the PC comments or complaints that are filed, the probable cause complaints? They have a lot of information. They are puked with a whole lot of information. The officers do such a fantastic job for the most part in those probable cause statements. Enough where a complaint can be filed. Enough. I can even read this complaint that was filed by the Siren Police Department. There is enough there, right there, enough there that a complaint can be filed. That is forthwith. And all you do is cut and paste and put their complaint into the complaint, or their police reports into the complaints anyway.
Judge, the probable cause statement, you may have noticed, does not state when the drinking occurred in regards to when the crash happened. Does not state when the moment of driving was. It does not state whether an officer was actually spat on or not. And it does not say whether anyone was injured in the crash.
Well, then that is a Siren Police Department issue that you can talk with Siren Police Department. But I'm going to tell you, our county boys and girls and women and everybody, all of our county people, our county officers and deputies, they put a lot into their probable cause, a lot.
They do.
And so then I guess with Siren Police Department people, if that's what you're saying is the issue here, then perhaps they need to be trained on how to put in all of the information in a probable cause. So we can forthwith have charges.
And again, I don't charge based on probable cause. I charge based upon beyond a reasonable doubt.
We will go on the record in the matter 26 TR 12, 26 TR 13, County of Burnett versus Jason Linder. The state appears through Assistant District Attorney Jose Vila in person. Mr. Linder appears in person without counsel. We're set here today in 2 ticket matters: operating a motor vehicle without insurance and non-registration of a vehicle automobile greater than 10,000 pounds. Mr. Linder, this is a status conference. What have you been doing? Have you registered your vehicle? Do you have insurance?
It's actually not even my vehicle. It's the vehicle I've been working on. I had just done a subframe swap on it and I was doing a test drive just to see if it's still driving straight. When the officer pulled me over, I've been trying to get a hold of the person that owns it. She doesn't have any money to even pay for the repairs, let alone get it registered. She's trying to sell the vehicle actually to try and pay
Somebody
for
owns
everything.
it.
So
Your Honor, if I may, we did give Mr. Lindner a letter saying that if he does not own the vehicle, we simply need something from the actual registered owner to say that she owns the vehicle and we will dismiss this.
Even just a letter because from the registered owner, because it doesn't sound like the individual that
From the registered owner.
owns the car. She's going to need, somebody needs, whoever, it's been registered, it's been owned by somebody
okay.
in the state of Wisconsin and or Minnesota and or someplace. So you need to get a hold of whoever you say owns it. They need to get a hold of the person who's the registered owner on the vehicle. And they need to get proof to the state and a letter stating that it is their vehicle, not your vehicle. But I don't know what happens if the person has passed away or if it's an estate vehicle or what not. You have to take care of it because otherwise you have these 2 tickets.
Okay, I never received that letter that I guess.
If you could go down to the district attorney's office and speak to Laura Christensen, she'll get you a copy of it so you can take with you.
Okay, that would be great.
A letter was sent, oh, just a letter between the two, not in
Yes,
the
Your Honor.
file. So go get that letter, figure out what you need to do, but you're gonna need to do it here soon.
Okay. I'll be on it right away today, so.
I need to get a next hearing date. I can give you a little bit of time to be able to do that. August 5th at 9:30. August 5th at 9:30. You can come back here and you will update the court. If you've taken care of everything and given it to the state, you won't need to come back. They'll just dismiss the matters, okay?
Okay.
You can come get your notice and you're free to leave. Mr. Martini. We will go on the record in the matter 26 FO 137, State of Wisconsin versus Keith Martini. The state appears through Assistant District Attorney Jose Vila in person. Mr. Martini appears in person without counsel. We're set here today in this matter for a status conference. This is a disorderly conduct matter. Mr. Martini, have you discussed this case with the district, with the state, the district attorney's office?
No, I haven't.
Mr. Vila, was a letter sent?
Yes, Your Honor, a letter was sent and we received a letter from Mr. Martini's wife that they, I guess, our previous meeting didn't go through because she had a chemotherapy session that impacted their ability to show up. If the court can grant me a little bit of time, I can step out to the hall and speak with Mr. Martini.
That
quickly.
sounds good. Go ahead and do that. Thank you.
Thank you.
As previously noted. Update, Mr. Vila.
Thank you, Your Honor. I have spoken with Mr. Martini. The offer as it stands is to take that anger management course with Mr. Dave Hatch. Upon successful completion, I will dismiss the forfeiture ticket in its entirety.
Excellent. All right. So Mr. Martini, you're going to take that class. Is that correct?
That's correct, Your Honor.
I will give you this form. It is not court ordered, so I will not fill out this form. It's your responsibility to do the class and to contact Mr. Hatch and to make sure that he contacts the DA and the court when you complete it. Because if you complete it timely and we get proof by that, by the next court date, you will not need to come to that court date. Okay, and this takes 4 weeks to complete and it costs $150. Okay, I have circled his contact information, and if you set up a meeting with him and you do not show, you will be assessed $25 for each no-show, which you will need to pay, or if you don't, I'll issue a warrant and you have to come back and tell me why you haven't paid it. Okay, but I trust that you're going to go to every one of these that you schedule. So there's the form. You can stay up here while you wait, because I'm going to get you another court date. Going to give you plenty of time to be able to get that done. Okay. You can stay you can stay because you're going to need to get another notice. Oh boy. Is August 26th time block? It's on the Schmidt week, but I'm gonna have to do that. We can do, let's do 9:30 on August 26th, 9:30, August 26th. So if you have everything done and you have it all completed, Mr. Hatch will send information to the state and to the county that you've completed it, then you will not need to come to this next date, okay? So this is 2 months out, should give you plenty of time, all right? All right, thank you.
Thank you, Your Honor.
Thank you, we are adjourned. I apologize, Mr. Benson. I didn't realize that you represent Ms. Nutt and that she may not appear. She may appear through you. I was waiting for the 10 o'clock. All right, we will go on the record in the matters 26 TR 203, 204, 205, and 206. State of Wisconsin versus Tiffany Nutt. The state appears through Assistant District Attorney Jose Vila in person. Adam Benson appears by video conferencing. his client appears through counsel. We're set today in these matters for status conferences. Mr. Benson, please update the court.
We have received an offer, Your Honor. My client is uncertain yet if we could have one more date, and that date might turn into a plea. So
You have not received an offer?
I have received an offer. My
Oh.
client's still deciding. So
Okay. Okay, just give me a second. I can do July 23rd at 3.
works, Your Honor. Thank you.
All right, thank you. July 23rd at 3 p.m. Thank you, Mr. Benson. And now I guess we'll just wait until Mr. Anderson appears, and then we're ready to go with the Bellinger matter.
Your Honor, he said he might be running late. I spoke with him on the phone a little while ago. He was behind a slow pickup truck or something, he said. So he's on his way.
Okay,
All right.
that's
Thank
fine.
you.
I'll just put the court in the waiting room.
Riff-raff, but I got through.
All righty. We will go on the record in the matter 26 TR 181 and 301, Village of Siren, Town of Menon versus Robin Bellinger. The state appears through, or the village and town appear through attorney Adam Benson by video conferencing. We have Bruce Anderson appearing by in person with his client. We're set today for a status conference. Mr. Anderson, can you please update the court?
Actually, Judge, I believe one of these cases, the more recent one, is 2026 TR 301. That's actually up for intake today. I did file written not guilty pleas just yesterday, but that's an intake one. The other one's up for status. I have discussed the matter with Mr. Benson. Mr. Benson feels he may have a conflict and is, let him speak to what his intentions are. I believe he may have to withdraw.
Mr. Benson.
Yeah, a couple of things, Your Honor. Both tickets should be Town of Menon, I believe. And then I had a conflict of interest come up with a defendant recently, and I would need to recuse myself, and I will reach out to Chelsea Whitley, as she's been taking on cases I have conflicts with.
All right, so is she going to take all 3 of these then?
I would ask her to, yes. So
Okay,
No, I'm confused. I thought there were only 2.
so
well,
did I.
wait, I have 18, no, there are 181 and I opened one of them twice. So it's 301 and 181. So she's gonna take both of these. Let me see when she is expected to be back. I don't have any court dates with her necessarily scheduled right now. So why don't I schedule it for something that works with Mr. Anderson, and then we can go from there. I have you coming back, Mr. Anderson, July 16 at 9. Maybe that will work, and if it doesn't work with Miss Whitley, then she'll let Mary know and we'll reach out for a different date and time. Oh, wait, is that on? What is that on? Oh, did I schedule that? I must have. Yes, and that should be fine because then I have a meeting, a 2-day thing after that, but it's local, so.
Yeah, I can make 9 a.m. on that Thursday, July 16. Yes.
All right, July 16 at 9.
Yeah, I have a rough day here.
All right, thank you, Mr. Benson and Mr.
I have
Anderson.
one
We'll
more,
see you
do I
then.
not? Does
Oh, you
Mr.
do.
Youngren? Yes.
I don't know if Mr. Youngren,
Robin, I have your notice
Nope.
here.
not here.
Well,
So I don't know if you want to, I do have an attorney, so just
Yeah.
wait.
Attorney Simon and I spoke
Yes.
earlier this week.
You guys are free to go. We will go on the record in the matter 26 TR 174, State of Wisconsin versus Andrew Youngren. The state appears through not the state, it's the Village of Siren versus Andrew Youngren. The village appears through Adam Benson, counsel. Mr. Youngren appears through his counsel, Attorney Brett Simon. We're set today for a status conference. Mr. Simon, please update the court.
Yes, Judge. I had an opportunity to speak with the state, well, the village, I should say, prior to today's court date. They want an opportunity. I don't want to speak for them, but I believe they want an opportunity to speak with their arresting officer before we can work out some sort of plea agreement for your honor's consideration. I'd ask for a pretrial conference date, maybe 30 to 45 days out. I'm hoping we can have this one wrapped up by that time.
Through District Attorney Kevin Schmidt in person. Ms. Honeycutt appears in person in custody with her counsel, Mr. Stroud. We're set here today in this matter for the restitution hearing. Are we both ready to begin?
Yes.
All right. There hasn't been any negotiations or any stipulations?
No.
All right. And for the record, Mr. Schmidt did file a letter indicating that he spoke with his witness, who is Robert Otto, who owns a jewelry store in Spooner. A million years ago, represented him during his divorce. I can let you know that I like Mr. Otto, but I can rest assured I would not take his testimony any higher than any other person's testimony. And it is all based upon credibility. But I didn't get an objection from you, Mr. Stroud or Ms. Honeycutt. I'm going to tell you, and I think you can even ask Mr. Otto, I am a very blunt, cut to the chase kind of person, and I see facts as they are, and I was very open and honest with him, as I recall, 10 or 12 years ago, maybe 15 years ago, very long time. And I can't even recall exactly. And the last time I saw Mr. Otto was maybe 5 or 6 years ago, running into him happenstance an hour or two away from this county on accident, or just ran into him. So that's all I can say.
Judge, we don't have any objection. I think it's on the court to determine whether you can be impartial or not. And I think you've made a record of that, which is, I think, what I expected to happen. We're all work in small towns, and you come across this from time to time.
It happens, and I can't believe it's been 15 years already. Holy guacamole. All right, so if we're ready to begin, Mr. Schmidt, you may call your first witness.
Yeah, I'll call Timothy Frey.
Please come forward, raise your right hand, be sworn in, and you can have a seat on the witness stand.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Oh, come right up here, sir. You may begin.
Can you state your name, spelling your first and last name?
Timothy Sean Fry, TIMOTHY FREY.
Did you have a safe stolen from you a couple years back?
Yes, sir.
And that's the safe that dealt with the criminal case involving Heather Honeycutt.
Yes, sir.
And at the time it was stolen, did you give law enforcement a list of the items taken?
A partial list of the items taken, yes. The only documentation that I had of what was in there.
Okay. And how did you know what was in the safe?
Prior, my grandfather passed away in 2012. My aunt was trustee of his estate, and she didn't do anything. She worked out at Microsoft out in Seattle. Didn't really finalize anything to do with his estate, and then she passed away without a will. So,
Stop you right there. You're speaking a little fast.
sorry,
My court reporter has to take everything
Sorry.
down.
Okay.
So I know that you may have.
I'm sorry, yeah, anxiety. Yeah.
Anxiety.
Mhm.
But just try and speak a little slower.
Yes, Your Honor. My aunt was trustee of his estate and didn't finalize anything, and then she passed away without a will. So I had to settle 2 estates in 4 different states, and I had a major issue getting inside of safety deposit boxes with the local banks. The one that my aunt had were those items that are on that list. I had to produce a personal property inventory list to settle her estate in probate. And part of that was taking those items and getting them valued.
So eventually all the items you took from the estate wound up in the safe.
Yes, sir.
And because I went through a property inventory, you just happened to have a list of all the items.
Yes, sir.
Were there other items also in the safe?
Oh, yes.
Did you, for the restitution claim today, did you submit a request for those other items in the safe?
I did not.
Why not?
I mean, I couldn't tell you exactly, what they exactly are with definitions, exact costs, how much weight does something have? That is not my expertise. I mean, since this court case happened, I actually was reached out from another person saying that she might have property of mine, and sure enough, she had one of my grandmother's rings. And again, I would have never been able to know that that was mine unless I saw it again. And the box is from the jeweler that my grandparents used in Illinois.
So you wanted to stick to the things you had, like you said, weight, value.
The things I
list.
knew, yeah.
Because some of the items in the safe weren't from the estate.
They were from other estates, correct? Not my aunt's.
When it went through the estate the first time for the property inventory list, did you get values of those items then?
I did in 2014.
How did you go about getting the values of those items?
I reached out to Mr. Otto, who I had done business with before, kind of explained the situation to him. I was like, I just need this to settle in the state. Never knew that this would come to this deal. He was able to help me out. He informed me that he's not going to take the time to do full appraisals on everything, as that would be extremely expensive. And then on the coins, we weren't going off of any collector value. We were just going off of bullion value.
So to clarify, you said you went to a Mr. Otto. Who's Mr. Otto and why did you go to him?
Mr. Robert Otto owns Sather Jewelry in Spooner, Wisconsin, and I have purchased items for my family through him before.
So you went to the jeweler to establish value of jewelry.
Yes, sir.
So when you first met law enforcement after the safe was taken and they asked you for the list of items and the values, were those the values as of the date the items were discovered missing?
No, I I was able, luckily, in my computer, buried in a folder. I had all the documentation from my aunt's probate. I was able to pull that list and print it on the spot to hand to them because I figured that it was important to get them that list of these missing items as soon as possible. And that value is based on the 2014 inspection or valuation from my aunt's estate.
So those were the unupdated values from 10 years ago.
Yes, sir.
Did you seek reappraisals during the case? The criminal case, I mean.
No, once I found out, after the theft happened, I did go back and speak to Mr. Otto and asked him if he could update the numbers for me so I had a better value for that for law enforcement, as one of the detectives asked me to do that.
Okay.
And that would have been March of 2024.
And then at some point, you went to him for one last time for the value as the date of sentencing.
After your office contacted me, when we were having the final restitution case, criminal case being heard, I went to Mr. Otto. He expressed that he did not want to be involved in any type of court case, and I feel awful that he's being drug into this, but he would not give me any new values. He just gave me percentages to increase based on the date of that I contacted him. So I pulled gold bullion spot price, I pulled silver spot price, and calculated those figures with the percentages that he told me to estimate from, which now have gone down. So, but that's bullion for you.
And so Mr. Otto was the one who created that or appraised those items back in 2016.
14. Yes.
14, sorry. And the list that you had from the estate, it described the items with specificity related to like their weight and what they were and cuts of diamond and whatnot.
Yes, sir. Correct.
Was that from you or is from that Mr. Otto?
That was from Mr. Otto.
So he put those notations for the descriptions of those items.
Yes, sir.
Okay. And you actually provided each individual piece for him to look at.
Yes.
All right. Were some of these items you reported missing eventually recovered?
A few of them, yes.
And did you submit a list of those items?
I have.
And you also put values next to them?
I did.
And you determined those values of those items?
Yes.
If you saw that list, would you recognize it?
Yes.
Okay. Do you recognize what that is?
Yes, it is a list of the recovered items that I have received back from two different meetings with law enforcement, from two different types of deals that I was able to get back some of these items. And these ones, I was told to actually research and do the full value. So even though my original estimate is bullion value, these values here are collectible values. So the original list, I mean, you look at that, 1972 Ike dollar worth $14,000. There's a lot more of those that were in that safe that I can't go off of collector value. I only can go off of bullion value.
So I'm going to clarify that distinction you made. The list you gave law enforcement, those values, you said those are bullion value. What does that mean?
Basically, gold, it would be $4,500 a troy ounce approximately, depending on the day. A troy ounce would be, divided out, and then a portion of that gold would be added to like a ring or whatever. They gold plated, solid gold, or gold plated items. Same with silver.
So it's the naked value of the silver and gold content in the item.
Correct.
And you said collector's value is how you did the items recovered. How's that different?
Basically there are coin collectors out there. Prime example, that 1972 Ike dollar, or let me use the Morgan one because I can remember that one a little bit better. But some of those Morgan dollars, the value is there's a collector value based upon which minted that coin itself. So on the Morgan dollars, there's a Pennsylvania mint or Philadelphia mint, excuse me. There was one in Texas, but the big one was Carson City. So if it down below, like on a quarter by the eagle's feather, there would be a little CC, and that means Carson City. Carson City coins fetch a much higher value than other coins do because they're more limited runs.
So the collector's value is more than just the silver or gold content.
Yes, sir.
So to clarify then, the list of items taken, you use the lower bullion value, and for the items recovered, you use the higher collector's value.
Yes,
Because are you trying to make like a conservative request for restitution?
I am.
Okay. How did you know the value of those collector items on that list?
Searched multiple collector coin websites. There's USA Coins, coincollectibles.com, and just search those. I also have no idea what condition those were in prior. I am not an expert coin collector, so I just kind of gauged it. There's usually 5 different values, which is like, good, very good, mint, collectible, never circulated in that regards. And on all of these values, I either used good or very good, depending on the condition of the coin after it was returned to me.
Okay. So just to finally clarify one last thing with the distinction between these two lists. So all those items recovered are on this list,
Yes, sir.
but they're on for just the silver bullion. So for example, the 1964 Kennedy $50 you valued in 2016 at $7, it would be worth considerably more collector's value.
Yes, sir.
Okay. Or that 1972 Ike coin you said is $14,000 a collector. It would be like $5 here.
Correct.
Okay.
Wait, what?
Yeah.
$14,000 as a collector, but it's only worth $5
In bullion.
in bullion. Okay.
I'll just ask one more clarifying question on
You're
that,
fine.
just off of
I
that.
know.
Collectors sometimes will pay more money for an item than the value of the materials in it.
For the rarity.
Because like you said, it being from a specific mint or a specific year or specific printing.
Correct.
Okay. So it's to Miss Honeycutt's benefit, use the lower value to evaluate it, but the higher value to retract from it.
Correct.
Okay.
In hindsight, I probably should have used the same value, but the detective wanted me to give them back the actual value is what I was told to do. So following orders.
And then you eventually, if you recognize that original list of items with values in their descriptions, would you recognize that?
Yes, sir.
Because it's the same one that you found in your, I think you said your computer from the estate.
Yes, sir.
Okay. And just while you're looking at that, please make sure it's separate from the first document I handed you. Do you recognize that item?
Yes.
What is it?
It is a spreadsheet that was created to do different values of different dates of all the different items.
Okay. And on that far left column, do you recognize the items in it, their descriptions?
Yes.
What are they from?
No, like the one specifically was the 14 karat 0.8 carat round brilliant cut diamond solitaire ring, weight 0.12 ounces, G VS1 quality. That was my grandmother's multi-generational diamond ring.
So these are the items from the estate.
Yes, sir.
This is the list of items from the estate you were just describing.
Yes, sir.
And the second column from the left, the one after quantity, top is labeled 3/2016 value. Those are the values from the estate originally.
Correct.
And then it's got a number of other columns for other evaluations, correct?
Correct.
Okay. I'd ask that those items be marked exhibits 1 and 2 respectfully. I'm gonna wait until the end of the hearing to enter them into evidence because I'm gonna use them for my second witness. I have no other questions.
Did you get copies of them?
I have copies electronically. Should we get them marked before?
I would say yes, and I don't have copies of them, so I haven't seen them. So why don't you just hand them to me and I'll just hand them over to the section.
I'm sorry. He told me to keep them
Oh,
separated.
sorry.
Apologies.
Which one is 1 and which one is 2? Generally, we have them marked prior to the hearing.
The first page will be exhibit 1. I'm sorry, the one that's just 1 page is exhibit 1.
One page is exhibit 1. And then exhibit 2 is 2 pages.
Correct.
And I'm not sure if you filed them as proposed exhibits. You don't practice in civil, so you probably don't know this. I don't know if Mr. Stroud knows this, but if you did them as proposed exhibits, I don't get them or get to see them until I receive them.
I didn't.
Okay, I just didn't know if you knew that. That was a change in CCAP, I don't know, about a year or so ago. All right, Mr. Stroud.
Thank you. Mr. Fry, so let's go back to 2012 and 2014 and your work as on the estates. I think your testimony was that your grandpa passed away in 2012. Is that right? And was that the grandpa on your mother's side or on your father's side?
Father, sorry.
And the aunt, your aunt, was appointed as trustee for his estate. Is that right?
Correct.
And then when did your aunt pass away?
I thought it was 2014. Now getting a little confused on this 2016 date, but I might. I'm sorry, I could pull the death certificates. I try to block some of that out. It's either 2012 and 2014 or 2014 and 2016.
All right, I think that's fine for our purposes. You don't need to get more detailed than that. And then you were appointed the trustee of your aunt's estate. Is that right?
After a long process, yes.
All right. And about just year wise, when were you appointed as trustee?
I believe it was approximately 1 month after her death, as we had to hire a private investigator to look for other next of kin.
So you were the sole heir.
I am the sole heir.
You are the sole heir. All right. So when you were appointed trustee, was this property, the estate property, was that all in one place at that time?
I was in 2 different banks. Well, my aunt's was in one bank. My grandfather's was in another.
All right. And at that time, did you bring them all together to be in one place?
No, I couldn't.
All right.
I couldn't get into both of them.
When were you able to get into both of them?
I had to get executor, be designated the executor of her estate. And at that point, I was able to get the paperwork to actually get into that safety deposit box. But until I was able to settle that and then have the lawyers pass all the other information over, then I could get into my grandfather's safety deposit box.
All right. So my question is, at what time did all this property come together into your possession?
After I got extremely upset with the banks because I couldn't get into the things I needed to get into because there was paperwork in there to do these estates. At that point, that's when I decided to gather everything up and buy a safe and bury it in the back of my pole barn,
Right?
foot of dirt.
Okay, and so what year was that?
It would have been 2017, probably, I would say.
All right. And that safe that you buried in 2017, that's the safe that we're talking about today.
Yes, sir.
All right. If I recall, didn't you have a contractor bury that safe for you in 2023?
Nope.
All right.
Nope. My mother, my father-in-law, and my wife and I dug the hole, and the four of us were able to use straps to lift it down in there.
Mhm.
And then it was closed and put dirt on top of it until my stepfather passed away, and my mother added things to it.
All right. And then when was that?
22, I believe. I'd have to, again, pull a death certificate.
And then from after 22, was there another time that you went to look at the safe?
Nope, never again.
Okay.
It was buried under a foot of dirt with deer stands and metal and different things in the back of the pole barn. You know, in the back corner where nobody walks or anything.
And when you had Mr. Otto look at these items, physically look at these items, where did that take place?
At his retail store in Spooner, Wisconsin.
And how did, and then when did that take place approximately?
Within a month after my aunt passed away.
And again, we established that would have been 2016 or 2014, somewhere in there.
Yes, sir. I apologize. I probably should have pulled a few more of these dates to be more prepared, so.
So I have to compliment you, even though you said that you are not an expert in collector coins, you spoke fairly knowledgeably about bullion value, collector value, and all that. Do you have some, before this case arose, did you have some familiarity with the value of coins and jewelry?
My stepfather was really into coins. He had very big into Wheaties, which are a very specialized penny. You know, so yeah, he kind of taught me some of that stuff and then just did my own stuff. I more just like the not collector value, but I'm a financial advisor. So I like to diversify my portfolio, and precious metals is an area of diversification I wanted to make sure that my estate had.
And your estate, so had all of these items officially passed out of your aunt's estate into your name?
Yes, other than my stepfather's stuff, which are not on this list.
All right. So if I understand correctly, none of these items were insured, is that right?
No, I used to do, before I was a financial advisor, I did property casualty insurance, which is PC insurance, like homeowners insurance. Inside of homeowners insurance policies, there's internal limits of liability. So most insurance companies will only insure up to $2,500 to $5,000 in total personal property labeled as jewelry. There's other sublimits like guns and jewelry and precious metals and things like that. The only way to get something on the insurance policy separately is to do a scheduled rider, which changes it to a direct physical loss coverage, and it is extremely expensive to do. Basically $90 a year for every $10,000. And that's years ago. I don't know what the rate would be now.
All right. So with respect to this property, before it was yours and it was property of the state, did you have it quote? Did you obtain an insurance quote? Did you submit any documentation for that?
I'm not sure if I understand the question. Could you
So-
repeat that?
Yep. While you were holding this property as the trustee of your grandfather or your aunt's estate, at any time did you obtain an insurance quote for this property that was entrusted to you?
I did not. No, it would have been too expensive for me to pay for if you want the reason why.
Well, it's pretty valuable property,
Yeah.
right?
Yeah.
I mean, you're saying this property is, the total value you're saying is about, well, today, $217,000, but even back then it was what? $60,000, what you said, right?
Plus, there's the additional cost of having to get an appraisal on every single individual item, which is usually $75 to $100 per item.
And I need to stop because I need to understand what it is, the amount that we're asking, because I have 3 different supplements to dispositional orders, restitution orders with 3 different amounts. So I don't even know what amount we're even seeking.
The amount is 200.
Well, just hang it, well, isn't that something that needs to come in through the
You
witness?
said 200 and some 17,000, right? But I don't even know what is even being offered. You said 217,000 at the last hearing. I was told 194,000. So, I mean, you can ask him and you can say, but you stated it. So that's why I need clarification.
Right, well, I would just, the point that I'm at, the topic we're discussing is whether any of this property was insured. I don't have the burden to prove,
No,
I don't have the burden to
if
prove
I-
it, I'm not trying
I just
to.
don't know what you're asking because you were saying it was 217,000 and then that made me go, whoa, that's not even what we were discussing was a possibility at the last hearing. In my mind, the a possibility was 194,000, perhaps depending on what the actual sentencing date was. So I was trying to figure out in my head the amounts by listening to him and doing those things. So you're not saying it's 217, then you're not saying it's 217, but that's the amount that came out of your mouth.
Right, because that's what's written on exhibit 2.
Oh. Okay. Worth of all of the property, correct?
Could I mention something, ma'am, that might help clear this up for you? Your
No,
Honor?
just he
Okay,
gets to
sorry.
ask questions and that's just the total amount that was written for the amount of the property.
Okay.
That's alleged to have been taken.
May I continue?
Yes?
Okay. All right, so after the property came into your possession, and it became your property, did you obtain an insurance quote for that?
I did not.
Did you file a tax return as the trustee of the estate for the property that was in the estate?
Yes.
All right, and did you put down a value for the property that was in the estate there?
Which estate are we talking about?
Well, let's start with your grandfather's estate.
My grandfather's estate was actually a living trust that bypassed probate.
All right.
So no to that answer and yes to my aunt's answer. Or to
All
my
right.
aunt's estate.
All right, and your aunt was the sole heir of your grandfather, right? And then you were the sole heir of your aunt.
Correct.
And so you filed a tax return indicating the value of this property when your aunt passed, sometime after your aunt passed, right?
Yes.
All right. And then when the property came into your possession, did you seek an insurance quote of any kind?
I did not.
And at that time, were you still working in the property and casualty field, or were you a financial advisor at that point?
Just a financial advisor.
All right. Let's talk about some of the items in this inventory. Far and away, the most valuable item, I think you'd agree, is these gold Krugerrand coins.
South African gold Krugerrands. Yes, sir. One troy ounce each.
Tell me about those coins.
There's multiple different countries that issue gold coins. In the United States, it's a golden eagle, which would be a troy ounce. There's also on that list, there's Canadian maple leafs, which are a troy ounce of gold, and there's also South African gold Krugerrands. They're just gold troy ounces issued by governments that people and collectors and people that are looking to invest in precious metals purchase.
And I'm just gonna stop. I don't know if you're going too fast,
Oh,
but these are
sorry.
all very
Sorry, I'm sorry.
different words than we're used to here. And so my court reporter,
I'm sorry again.
it's very hard for her to take it down fast, especially words that aren't in every day.
And at the time that you acquired these coins through the estate, were you aware of their significance?
Which coins? The gold ones?
The gold Krugerrand coins?
Yes, gold Krugerrands fetch a little higher dollar amount than gold bullion spot price. Not much though.
And how about the gold Canadian maple leafs? Tell me about those, because those are also a significant portion of your valuation here.
The exact same thing. My family likes to collect precious metals. So rather than putting money into a CD or something like that, they bought gold.
So sit in the financial advisor seat for a second. If you have a client that's going to acquire coins like this as part of their portfolio, what would your advice be to them in terms of acquiring those items?
I would tell them to put them in a safety deposit box or put them in a safe somewhere where no one would ever find it.
And would your advice be to that person to insure that item?
It would depend on the person, to be truthfully honest. Most of my clients and most people that collect precious metals don't want, no offense, don't want the government knowing what they have. So most of them do not do that. I can tell you that.
All right. And is that one reason why you didn't want to get this stuff insured?
Partially.
So, and the government not knowing that you have it, so you don't pay taxes on it? Is that what that is a reference to?
I mean, what conspiracy theory do you want me to go down?
Well, maybe your conspiracy theory is probably the most relevant.
You know, I mean, just truthfully, like, you know, I had to claim the stuff that was in my, aunt's estate. My grandfather's stuff literally passed with the living trust to me. I don't want the IRS, the government knowing what I had, because that gold bullion is worth money, you know? It's kind of like they see everything that are in bank accounts and your 401ks and everything else. It's, you know, other than burying cash in a safe, it's very similar. You can't insure cash. It would be the same thing. Like especially for people that don't trust banks. You know, a lot of customers bury cash, but that can deteriorate. Precious metal cannot.
So these coins come from banks, do they not?
You can get them from multiple places.
And so as someone that wants to know what they're actually getting in terms of precious metals, wouldn't you agree as a financial advisor, you would want that person to have some kind of certificate of authenticity or something of that nature from the mint?
That's up to the client themselves and how comfortable they are knowing what, or having other people know what they have.
And so you're saying that you had in this estate, there were 20 gold Krugerrand coins. Is that right?
Yep.
And you're saying that there were 11 gold Canadian maple leaf coins. Is that right?
Correct.
Do you have a certificate of authenticity or any proof of ownership for those items for you, your aunt, or your grandfather?
In the safe.
It's all in the safe. You didn't make any copies of those items and save it in your computer? None of that was filed or kept as part of your record keeping responsibilities as trustee?
Not in my grandfather's estate, no. Everything that was required of me from my aunt, everything that was required from me for my aunt's estate for the executorship was documented, which is why I even have a list of half the stuff that was in there.
Was your grandfather a coin collector?
Uh, somewhat, a little bit. He also had some stamps. He was a sailor mostly,
All right. And,
chemical engineer.
all right, and then your aunt, was she a coin collector?
No,
Did they, so obviously both of them trusted you and held you in high regard. They appointed you as someone to administer their estate. Is that fair to assume? Or did it just default to you?
it defaulted to me.
All right, so you weren't, they didn't pick you out as someone to manage their estate by name.
My grandfather put me as a secondary trustee
All right.
behind my aunt. But again, I'm also the sole heir. I don't have any brothers or sisters. My name dies with me. Well, not my son, but yeah.
Questions?
Mr. Schmidt,
Was the value of either of the estates in 2014 and 2016 more than $5 million?
No,
What were the values? Ballpark if you don't remember it.
my aunt's was probably close to 400. Well, hold on. We have family farmland that is held in a trust. Do I account for that in this answer?
Whatever passed through the estate.
Whatever passed through the estate, then hers would be, and then her estate would have been approximately 400,000, 450 maybe.
So neither estate went anywhere near the estate tax.
Correct.
And to clarify, the only value you calculated for as of time of sentencing was the collector values of those coins on what was Exhibit 1.
Correct.
That final number was 22,717.
As the day of sentencing per our looking into that, yes.
And Bob Otto, as the jeweler, would be the one who would know about the value of the other items
That weren't in the list? I'm sorry?
that were on the list.
Yes, oh, yeah. He's the expert. He knows probably gold spot price daily. I don't look at that daily.
Okay, no other questions.
any recross?
No.
All right, you may step down. Thank you.
Thank you, Your Honor.
Have those marked exhibits up there.
I do. Generally, they provide a copy for the court as well.
Sure. Before I call my next witness, would you like me to just provide copies to everybody?
Well, generally, you're supposed to provide copies of exhibits to everybody.
Okay. I shall follow the court's instruction.
Thank you.
Object if I provide copies of the exhibit I'm going to enter right now as well.
This is what you gave me in the hallway earlier?
Mhm.
That's fine.
And generally, they do, yeah, well, in civil matters, they do, and then it's wait until you ask it to be received.
I apologize. I reviewed the restitution statute prior to today. It said it does not follow civil principles. It's supposed to be informal with no rules of evidence.
Exactly. I'm just saying that's the customary procedure because otherwise, especially with something like this, I don't know this stuff. It's easier if the court follows along with it while there's testimony because I don't know this stuff. Oh, do you need to get it marked? I don't know what it is.
All right, for my next witness, I call Robert Otto.
Mr. Otto, please come forward. You're going to stand right here, raise your right hand. You're going to be sworn in and come have a seat at the witness stand.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
I see that you brought something up here, Mr. Otto. Okay, do not look at that unless you need to refresh your recollection. Okay? And then if you need to refresh your recollection, then you can look at the document, just say, I need to refresh my recollection, please. Look at the document and then put it right back down, okay?
Certainly.
Thank you.
And I can tell Attorney Stroud, I can recognize that document from here. It is Exhibit 2, but the original of it.
You may begin, yes.
Could you state your name for the record, spelling your first and last name?
Robert Warren Otto, Robert Otto.
What do you do for a living?
I own a retail store, a jewelry store in Spooner, Wisconsin, Sather Jewelry.
How long have you owned that jewelry store?
20 years.
And have you been operating it as the jeweler at that store for 20 years?
Correct.
In your work there, do people ever bring in pieces for you to look at?
Almost every day.
What do they ask you to do with them?
Evaluate, to give an informal valuation. Sometimes people are just curious. Sometimes people have inherited items. They have no idea what they're worth. Every now and then, it's a request for appraisal, like a more formal valuation where they're trying to sell something publicly or online. Sometimes people want to bring jewelry in for me to buy it from them for scrap, in which case I sell to a refinery in the Twin Cities. Probably most people are coming to have me buy their jewelry, that they don't want any more scrap jewelry. And probably 30% of the time they're coming for just an informal valuation.
Okay. So you have to figure out the value of items frequently.
Every time.
How do you go about doing that?
A lot of it is simple math with tools of the trade. I need a scale that's licensed by the state of Wisconsin. I need a calculator. I need a jeweler's loop. I need a gold tester. I need a diamond tester. I need a digital caliper to measure and estimate the carat weight of diamonds. And those are the tools that I need to perform a valuation.
And you have all those at Sather's Jewelry?
Correct.
And you use those to appraise items?
Every day, yes.
Did you ever appraise items brought to you by Timothy Frey from some estates he was a personal representative of?
Yeah, I would distinguish a word, and it's an important word in the trade, and that is appraise. I was giving valuation, appraisals, particularly appraisals that are brought in for insurance purposes, insurance replacement, require a license that I do not possess. I can perform appraisals, specific appraisals for insurance purposes, for the jewelry pieces that I sell from the store. What I provided for Mr. Fry was a valuation that was not for appraisal, but had replacement and the resale both in mind. So there was not a specific purpose identified at that time. Just said, what do you think these are worth? And so the bullion is very straightforward. It's just math. Like the Canadian maple leafs and the Krugerrands, the silver bullion. It's just math correlated with the daily spot price of gold and silver. The jewelry is more subjective. It involves calculating or ascertaining the purity of the gold with the tools that I have, and also by my jeweler's loop to identify markings, 14 karat, 10 karat, which set out the purity of the gold, and I'll evaluate the diamonds by jeweler's loop and my many years of experience. That's how I arrived at those numbers.
Okay. If you saw the list of those items, would you recognize them?
Could you clarify the question?
For that evaluation, you made a list of items and values for them, correct?
Correct.
And if you saw that list, would you recognize it?
Oh, yes, and yeah.
Okay. I'm gonna bring up Exhibit 1.
That might actually be. I had that as Exhibit 2, or at least came in second. All right. And is that the actual exhibit, or is that your copy of it?
The actual exhibit. You recognize what's been marked as Exhibit 2?
I'm free to look at that document right now.
Yes, you are.
Yes.
What is it?
It's a setting out of my valuation. It looks like 4 different dates. March of 2016, the second column, March of 2024. A third column, March 2026. The last one, as instructed by the district attorney to produce a document tied to the precise gold and silver spot prices on June 9, 2026 at 1:00 p.m.
And let's first talk about that first column. What's that first column?
The first column is a valuation based upon my direct handling and investigating and then writing down on paper, I think at the time, all these items here. And at the time, I don't believe it was a typewritten. I can't recall if it was a typewritten document or it was handwritten. But every item was carefully examined and identified with a valuation number by the side.
Okay, so you are the one who determined these descriptions based on your examination of each item.
Yes.
So for example, very top item on the list, working vintage 18 case Omega automatic watch. Could you describe how you describe that and how it carried through to the evaluation?
Okay. The watch is handed to me, or it's in front of me. I first get up my jeweler's loop. I will look for stampings and markings to check the purity. This particular watch was identified with a stamp 18K and Omega on the dial, which would indicate, it would suggest that it's a genuine. I've handled many fake watches in my time, fake Rolexes, not many fake Omegas, but I tested the gold with my gold tester and it came out to be 18 karat, which means carat with a K represents a purity scale based on the number 24. You may have heard that 24 karat gold is the purest of all gold. Well, that's 24 over 24ths pure gold, or 100%. 18 karat gold means that it's 18 24ths pure, or 75% pure gold. In this case, it's the one item on all these listed where collector's value is considered, because the value of that watch is a piece of jewelry, and a watch with the stamp of Omega on it is is considerably more valuable because of the name brand on it than just the sum of its parts. Because the watch is a single working watch. I'm needing to make an estimation on how much of that is gold weight, how much are the guts of the watch. I don't want to bore you with all that. At the time, I remember going online to try to get a feel for the collector's value, which I will do if I need, I'll research. And that was pretty much in the main for that particular watch. I was able to identify that online, eBay, other places. And so I assigned a basic value of $4,000, which I recorded at the time.
And then later, when you were checking for the June 9th, 2026 at 1 p.m., you gave a different value. How did you determine it then?
That was, it only went up $500. It was below the 5,000. That was the biggest jump from 4,000 to 5,000. And a lot of these numbers are lower than what they could be. I didn't want to just jump up the price. So the 4,500 would represent maybe the watches haven't gone up a lot in value from a collector's point of view, maybe even down a little bit over the last 10 years. So that would explain why there wasn't a big increase in the number. Plus, over time, in our industry, watches are the toughest thing to actually sell. So there's a bias toward, okay, what would you actually get for this if you wanted to sell it? And so there was a push-pull with the initial valuations, because on the one hand, there was the idea of replacing these, which to replace any of these things would cost more because it would mean retail. On the other hand, Tim was looking for a valuation, so I'm kind of pulling the prices back, was the idea of, well, maybe he wants to sell these somewhere, and try to give him an idea of what he might be able to get for these. Like that would explain why I would go online and check eBay for pricing. That isn't a retail price, that's trying to make it sellable for somebody. So that was one specific case where if he actually had to run out and buy that now, he might pay a lot more for it. But my bias is always toward if he wants to sell this. So, and then you clarified that, state law by statute said that this list needs to be a matter of replacement value and not sale value if Mr. Fry had to go out and purchase these things. But I was just stubbornly keeping a low number at $4,500. Just anybody could just inflate all these numbers basically to whatever number they'd want. But I've always tried to keep things honest and with a bias toward being fair.
So it's a conservative estimate is what you're getting at.
Conservative
And
would
that
be a good word for it.
that 4,500 represents the cost of replacement.
Yeah, and it might be a lot more, just depending on, how badly he wants to watch and where he might be able to find that in the marketplace. It'd be a tough find right now, and it might cost considerably more. But again, I'm keeping a conservative number for the court.
Some of these columns, the number on the far right has a letter, either a B or a C. Let's start at the very top by the Krugerrand and the Maple Leafs. What does the B indicate next to those numbers?
By the very informal scripted key on the left, B represents the word bullion, which is metal in its purest form in a coin, and represents a purity nearing 100% pure, 999. In the case of most American coins, 9999% to the 10,000th of a percent for Canadian maple leaves in particular. That's bullion. Coin, for purposes of setting out this valuation and disposition of Mr. Fry's possessions, most of the coin presented was 90% pure silver coin, dated 1964 and previous. There were a handful of other face coins dated following 1965, explaining the low value. So B is for bullion, C is for coin. Sorry for the long answer.
Okay. So let's take that gold Krugerrand gold coin at the top here for an example. How did you determine the value of that in 2016 when you looked at it?
It's all math beyond just the initial identifying. Now, I need to clarify too that these coins were in my possession, handheld, tested with my gold tester, weighed for weight, measured for circumference and diameter, and not circumference, but diameter, and thoroughly tested. Once I test a sample of a number of coins, I'll assume that the rest belong to that same set are going to be legitimate unless something, might appear funny. But I've handled many thousand bullion coins, but I test in every circumstance just to be certain, because there's more fake out there these days. But those tested 24 karat with my gold tester. The Krugerrands, all tested, they're all 1 ounce coins, 999 pure. And so I know that they're going to be 100%, basically 100% pure. I put the weight on the scale, and they'll measure 1 ounce to the 100th of an ounce. At that point, I know that I have 1 ounce that's 100% pure gold. And so it's a simple matter then of just multiplying that by the spot price of gold that's published every day. I get from Kitco Spot Gold, one of the more reliable gold purveyors of gold in the US. And then I am able to arrive at a perfect number. For the purposes of replacement, however, I have added additional value of 10%. And that is because if Mr. Fry were to want to replace that missing gold Krugerrand, he would need to purchase that from a purveyor of gold, a gold bullion dealer likely, who would, in an effort to stay in business, would charge a 10% premium above the spot price. So for instance, if gold is $5,000 an ounce, the spot price right at this moment, and there's a 1 ounce Krugerrand on the scale, I'll know that 1 ounce, that is going to have $5,000 of precious metal value. However, if someone's wanting to purchase one like that exact coin today that has $5,000 of precious metal value, they will need to pay an additional 10% premium in addition to the base amount of gold. So that would mean replacement value on that 1 ounce Krugerrand would be $5,500 and not just $5,000. I have added that 10% premium into these final numbers of 101,728 for the bullion Krugerrands, the 20 of them, and $55,450.40 for the 11 Canadian Maple Leafs. It's math. That's the math of it. That's the beauty of, and it's the fairness of just doing the math on it when you know that you have a genuine article in front of you. It's just simple math, calculating it out.
Okay. As part of that description, you described using a gold tester to test some of the coins. Could you just clarify what that gold tester is, how you use it?
Yeah, at the time, 2016, I was using an oral gold tester. I forget the exact model number, but had a very high, probably 96, 97% accuracy rate. I had one previously that didn't perform so well, and the technology has improved. So it was the latest, the best one that I could buy, and proven by many jewelry stores, was purchased from Stellar Incorporated. That is the largest seller of such jeweler's tools in the country, and bought the finest one that I could get for the money.
Okay, so that's the device you used, and that was the common tool of the trade to use at that point in 2016.
Yeah, it was the best one money could buy in 2016. Was that the first one? I'm trying to read it. My eyes are a little blurry. The initial valuation when I actually held those Kruger's in my hand. Yes.
Okay. And you also weighed those items as well.
Absolutely. Every time.
Do you still use the same scale as you did back in 2016?
As a matter of fact, I do. And that's the scale that I brought along. I don't know, I'm going to submit that as evidence, but I'd want it back.
We're not going to submit that.
Okay.
So that tool you mentioned at the start, is that something that's certified by the state?
Yes, it is. Now, the state didn't start certifying the scale until the last couple of years. It was a scale I've always had. But when I received my surprise inspection by the state inspector a couple of years ago, that was the scale. And that was tested with, he brings in a series of weights and is able to ascertain if that scale measures within tolerances to be able to license it. And that scale was licensed.
So the scale wasn't reviewed or certified until 2023, and that's the first time you ever had a visit from the state.
The first time it was officially, the first time I ever had a state inspector in to evaluate it, but that was the same scale that I used at the time of this evaluation in 2016.
Do you do anything to continue to calibrate the device or anything like that?
Once you calibrate it, it pretty much just stays true. And I don't calibrate it every single day. But when I drop random things like a Kruger on top and it comes out 1.000 ounces, that is an indication that, because what are the mathematical possibilities it's going to err up or down even by 1/100 of an ounce. So I do have a 200 gram weight that periodically I will apply, but I don't test it on a daily basis.
Okay. But you've been testing it off and on since 2016 when this happened.
Correct.
And would you recognize the certification that happened in 2023 when
Travis?
the Department of Agriculture, Trade and Consumer Protection certified it the first time?
Yes.
Okay. I don't recall that.
Did you call it Traz?
Travis, I think that was the name of the inspector.
Oh, Travis.
Yeah.
Okay.
You recognize the document I showed you?
Yes.
What is that?
This is Wisconsin Department of Agriculture's certification that Travis Soper, Inspector 198, physically tested my scale and signed it, licensing it as a valid device that I could use in the state of Wisconsin within tolerances. And I don't quite understand all the numbers or the error numbers, 0.1 troy ounce, I would guess, for 500 grams. And I don't understand the exact language of that Travis used. I'm just happy he signed that it was a good working and an honest scale
Okay,
that I could use freely with the public.
okay. I'm going to ask you next about a couple other items on here. I just asked you about an item with a B next to it. Let's go to the first item with a C next to it. I believe on the list, going from top to bottom, the first one would be Washington Quarter Collection Books, 1932 to 1964. What does the C mean?
That means coin. And that's that's the one, I think it's the one item on the whole, well, I didn't pop them all out of it came in a book. I can't recall the number of them that were in the book. I may have counted them at the time, but I don't have that number delineated here. I can't recall if the book was completely full or not, again, how many quarters, and I wasn't going to pop each quarter out to put it on the scale to weigh, because it was a collector's book. So I probably just made, because they were 1932 to 1964, that means that they would have been all 90% silver. I made a guess, an intelligent guess, to get to the $250 number. Totally irrespective of any collector's value. I wasn't looking for the 1950D quarter, which my folks were coin collectors. I wasn't looking for those dates to ascribe any additional value other than the precious metal value. Because when it comes to coins, I'm not a coin person. I can't ascribe any collector's or numismatic value, as is referred to in the coin world. My expertise is in precious metals. So I tried to keep the valuations tied to the things that I knew about. I didn't want to wade into speculating into collector's value where I don't know a lot. So that is largely tied to, the $250, it rises with the increased price of silver, and then pulls back a little bit from 500 to 450. That was an intelligent guess, but not an actual formal weighing of every quarter, because I kept it in the book.
Okay. But this one, you also, even though it's labeled C instead of B, you again connected it to the precious metal content and the bullion price of that content.
Right. And again, bullion is only referred to 99.9% pure metal in a coin, or a silver bar or a gold bar. So bullion is pure precious metal. Coinage I'm referring to constitutional coin minted by the United States Mint. That 1964 and earlier was 90% pure silver. So most of the coin that is delineated in this list is 1964 or earlier constitutional coin that is 90% pure silver. And that again gets back into the precious metal value, which I've calculated out. And again, for replacement purposes, added 10% if Mr. Fry were to have wanted to replace those coins with new coins of the same date.
So once again, for this one, you figure out the value of the precious metal inside and just multiplied it using math with the number of that time.
Correct. And for the calculations at the bottom of the page, the last 6, 7, 8, 9, where I have precise weights in troy ounces, where there was a bag of, something, those I actually physically put on the scale. They weren't in a collector's book. They were loose. So I put them on the scale. I took them out of the bag just so it was just the coinage. And knowing that they were 1964 or earlier, I would arrive at a gross weight, and I'd multiply that by 90%. purity, which would give me the weight of the precious metal. And then I would multiply that by the spot price of silver, $65.42 an ounce, for instance, at the very end, the last number there. And then add 10% for the premium if Mr. Fry wanted to providing a replacement cost. That explains the fourth column.
You keep referring to this 90% number for coinage before 1964. How do you know that?
Longstanding research, survival in the jewelry industry. You get it wrong one time, it pops up the next day in Rice Lake and Hayward and Siren. So you get it right early. And I've been getting it right for about 20 years.
Is it a historical fact that the mint?
It's a historical fact, yes.
Okay, that they did it at 90%.
Purity. It's well known. Yeah, it's a well-known fact.
Okay. So most of these items on the list don't have a C or B next to them. Let's take, say, one of these diamond rings. I think towards the top of the list on the left, the first item that starts with 12 kW.15 CT, old mine cut diamond solitaire ring. How would you calculate something like that?
Let's see, where is that on the list?
First page, and if you're just looking at the start of the terms, it's the first item with 12 kW next to it.
Okay, 12. So that would have been a ring, likely tested at 12 karat, white gold, a 0.15 carat old mine cut diamond solitaire ring. That might be, for whatever reason, that might be one of the only ones that at the time I didn't put on the scale. I think most every other ring is going to have a gross weight on the scale. So I can't explain why I didn't do it there. That could have been just something that I missed. Though I would have put it on the scale, I would have gotten a gross weight. And because again, 12 karat means that it's going to be 12/24 pure gold or 50% pure. And knowing that whatever gross weight was on the scale times 50% would give me roughly the gold content that I would multiply by, at the time, gold was $1,250 a troy ounce back in March of 2016. And once I would arrive at the basic precious metal value, I would use a multiplier of 3 or thereabouts, depending on the quality of the ring. And that would give me kind of a value closer to replacement value than resale value, but not full replacement value. Then I would also consider the 0.15 carat old mine cut diamond, which, I would have my own valuations in mind and would add the gold value, which is more mathematical, with the subjective grading of the diamond to get the $500 that I arrived at in March of 2016.
So you examine the diamonds or whatever stones are in them to determine those values as well.
Correct, with a standard jeweler's 10 power loop.
How do you determine the value of things like diamonds or other gemstones?
Well, it starts with figuring out if it's a genuine diamond or a lab diamond. I have invested $7,000 in a diamond tester. I also have a kind of a frontline $500 diamond tester, which I use commonly. In the case of an old mine cut diamond, the likelihood of that being a lab or a synthetic is next to nothing because no one cuts them that way anymore. They were old mine cut diamonds, have small tables, and they're taller and narrower, and is the way they were cut back in the 1880s to 1900. So that was a case I probably would have used the lesser of my two diamond testers, not thinking that it's going to be a synthetic or a fake, and it tested as a real diamond. And then probably put less value on it because old mine cut diamonds, especially 10 years ago, were regarded as just poor cut diamonds. And so again, the bias is low. A tricky thing in assigning value is, if Mr. Fry or anybody else would ever want to produce a duplicate of any of these, it would require, because they were vintage pieces, they're not going to be line items, line pieces that you could purchase from a modern manufacturer. It would require a custom jeweler and a goldsmith actually designing something, and then, CAD designing it in a CAD program, and then creating a wax, and then casting it, and then finishing it and making it. You could easily add more than $1,000 to any of those numbers if there was sentimental attachment, and Mr. Fry or anybody else would actually want to replace one of these pieces. So I want to say that because that would be the upper end, the highest kind of value you could put on something like this. But I haven't applied that in any of these valuations. Not one is considered replacing it with an expensive custom made ring to replace maybe a sentimental piece that had been lost or stolen. The valuations that I have are very conservative on the replacement side, and even are pulled back a little bit because at the time, Mr. Fry was just looking for a valuation. It wasn't even so much, I don't even think the word insurance was being used. It was just, what are these worth? And when people say, what is it worth? It could mean, what are these worth to replace? It could also mean, what are these worth to, if I wanted to sell these, what kind of money could I get for them? And so I'm providing something, a number kind of in between, but a little more like actually replacing it. Thinking, well, if you lost these are probably vintage pieces, you'd want to replace them. But I could have gone a lot higher with the replacement. So these are conservative numbers that I'm presenting at the time, and never once considered this would ever land in court. But 2016, it was the purpose, the setting out of these numbers was to try to serve Mr. Fry with a number that might give him an idea of what it might cost to replace, but maybe close enough to what maybe he would get if he would ever want to sell it.
And selling value is lower than buying value.
Oh, yes. And sometimes 50% less.
And in this case, these items, the ones that don't have the CRB and X, the jewelry items, you figured out these values from the precious metal content and precious gemstone content.
Correct. Evaluated both the weight, which is more of a math thing, finding precious metal, the base from the gross weight, how much gold is actually in it, multiply by 3. And then a separate valuation of the gemstones added.
And the way you determine these values, is this the commonly accepted way to do it in your trade?
Yes.
I mean, you've operated a successful jewelry business for 20 years, right?
Correct.
How did you, so you put the values in for both the far left and the far right column, the 2016 and the 2026 column?
Yes.
How did you determine the 2026 value on these items from the 2024 value?
I didn't have the pieces in hand. I didn't have the benefit of holding them. I didn't even have the benefit of holding them in March of 2024. So at this point, I couldn't rely on I couldn't rely on knowledge of having the ring in hand like I had in 2016. So mostly I'm trying to figure out, and I think what I did, what I would do, and I'm today, probably the same I probably did back then, is I would consider, okay, so gold jumped from $12.50 an ounce to $21.61.70. So that's, that's roughly, it's not quite double, maybe 70-80% more. So, but diamond prices didn't go up that much. So I probably in my mind assigned, okay, there's the gold side that bumped up 80%. But the diamond probably didn't go up that much. So it wasn't just a 1 point, it wasn't multiplying by 1.8 or 1.9, just jumping it up there, because I knew that the gold was just a piece of the value. So, but it obviously moved in the direction, the number got bigger and then got really big from 2024 to 2026 because the price of gold more than doubled. So, but again, my jumps were conservative. Because it was always keeping in check the fact that the initial purpose of it was to give a valuation that might be tied to what maybe he could get for these if he were to sell them versus replace them with custom jewelry or with manufacturer's line, piece that might be similar.
So to clarify then, is what you did, you looked at the descriptions from that when it was in your hand in 2016 and calculated using June 9th, 2026 values.
Correct. And that is it's an estimation. It's not precise because, well, in the case of the bullion, it's absolutely precise because the weights never change on a 1 ounce Krugerrand. All that changes is the spot price of gold. And likewise for the silver coin. So I got a little lost in the weeds.
Sure. So like, for example, we'll take one. I'll ask you for an example one. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 items down the list. Item described as 14 KTT 2.0 mm round, full cut diamond solitaire ring, weight 0.055 ounce. How did you say translate the 2016 value to now?
Okay, so that one is very straightforward because I dropped the ring on the scale. I'm not pulling out the diamond. I'm just counting the diamond as if it were gold, which biases it up, just a couple hundredths of a percent, probably not a lot. So I dropped the 14 karat two-tone yellow, white, gold. I test it. I look for the stamp. I test it, then I put it on the scale, and it was showing me 0.055 troy ounces of gold. And I would know in 2016, then to multiply that number by 1,250, which would give me a base amount, and I would multiply that number by 3. Then I would look at the quality of the 2.0 millimeter round, full cut diamond. Full cut would mean that it's going to be a more modern stone. It wasn't a big enough diamond where there's going to be a big, I looked at it, and because I didn't put any notation by it, like G, VS1 or GS, is mostly because it's probably clean, but I didn't put the time into, color, clarity, and because I told Mr. Fry at the time, I'm gonna work smartly, but I'm not gonna do a full-fledged, GV color and clarity evaluation of every single diamond. But I know what those are by book, 2 millimeter, and I probably would have been biased kind of in the middle or to low. What I would judge as the clarity and the color of the stone. And then the thing that I couldn't reproduce, but in assigning value to that first column, I would look at the condition of the ring. Some of the rings handed me, I'm guessing, had, some wear and tear on them. Some may have looked in more pristine condition than others. That was all information that I didn't have in column 2 and 3 in the subsequent visits and the completion of column number 4. So I was making some subjective judgments as to the overall quality of the ring, though mostly it was attached to the gold, which is just a formula, it's math. And then you'd have the diamond with my loop in hand. In the bigger diamond, for instance, the 0.80 carat, there I did provide a, G VS2, G in color, VS2 clarity, because that a difference, 1 degree in difference in color and 1 degree of difference in clarity can mean a 10% difference in the value of a diamond. So that's right. I included it in the larger diamond, but I didn't put color and clarity in all the smaller diamonds. But that would be, again, math in the ascertaining the purity of the gold, testing it, looking for a stamp on the scale, purity of the gold multiplied by the weight on the scale gives you the precious metal value 3 times, times the spot price, gives me a basis for the metal, and then add to it the more subjective valuation of the diamond, testing if need be, putting the diamond tester on it, and then giving a combined value in column 2016. But then column 3, 4, 2, 3, and 4, I didn't have any of those pieces in front of me to go back, and probably at that point didn't even remember what they looked like. But boy, I sure had my hands on them that first time.
But that's what I'm asking. I'm asking, so you had it the first time, you described how you established it in 2016. How did you calculate it in column 4 of the 2026 based off of the first 2 columns?
Yeah. So again, it's gold jumped. I mean, I don't have the percentages, but gold jumped from $1,250 an ounce to $2,160, $170. And at the time I calculated out what would be a fair raising of value with a 80% jump in the gold price. But there wasn't an 80% jump in those prices from column 1 to 2. Is probably less than that because, not all the value was calculated on gold value. Some of it was diamond, and diamond value pretty much stayed static during that same time. So that's why it's not, I didn't just apply a formula of, oh, gold's up, say 80%. Well, I'm just going to multiply that number by 80%. I didn't do that. Understanding that the gold was just a slice of the value.
So you did do multipliers, but you considered the other items in the piece and determining how much of that multiplier.
Correct. Yeah.
Okay.
Which means that it wasn't just a simple calculation based on, oh, 1250 gold jumped to 2161, divide that out, find the percentage, and then multiply that down the list. I didn't do that. And same with when gold jumped to 5,100 an ounce, March 2026. I didn't just figure, oh, that's 2.2 jump, and then just do that as a multiplier all the way down. Always keeping a conservative bias.
Okay. And just to clarify, the way you obtained the values of, say, gold spot price average, silver spot price average, how'd you get those?
Every day, almost without fail, probably every day for the last 15 to 20 years, I'll look at the Kitco spot gold price every day, as it's the backbone of our industry.
And just so we have it for the record, because you said Kitco.
Oh, Kitco, Kitco.
Thank you.
Kitco.
And what is Kitco?
Kitco is a purveyor of gold small refinery, but they are known for their everyday published spot price of gold and silver that are relied upon by bullion dealers across the country and jewelry stores.
So it's
For
common
accuracy.
for people in your profession to rely on their numbers.
Yeah, and it's the price changes maybe every 15 seconds. So at any moment I consult, it's exactly what the price is, but it could change 30 seconds later.
And the tools you describe using for measuring these items, the jeweler's loop, the gold tester, the silver tester, et cetera, those are all commonly used tools of your trade.
Correct. And I specify gold tester. The silver is a little bit tougher, but there aren't any pieces here that are sterling silver that are delineated. Just silver coin, which can be verified by weight and by being held in the hand. And because I've held a lot of constitutional coin in my hand too, through the years.
So we described a couple of example items on this list. Did you consistently apply the same methods of examining for all the items on the list?
Correct.
The same as those examples?
Yeah, I strive to do that. Maybe I didn't do it perfectly. There was one item that you indicated where I obviously forgot the one with assigned $450 value where I don't have a gross weight on the ring, the old mine cut diamond. So I was in error there.
Okay.
Which can happen in, doing a number of items.
And ultimately, when you applied that process to all the items on the list, you came to $217,012.60.
Yeah, adding it all up, I would need to look at page 2. Again, and I put them in order of just kind of rock solid values because the total bullion, and that's the pure 100%, basically 100% pure gold and silver coins set out in this document came to $160,851.91. And if accepting that the bullion is genuine bullion, which I tested, that value is right to the number, but includes the 10% premium added. So that really is just straightforward math. There's no subjectivity involved in it. The total coin, that relates to a lot of the items on the bottom of page 1. Some of the larger numbers, 1,700, 1,100, 1,400, 1,600, 600, 700. And that's 90% silver coin, constitutional coin. And there's a handful of, there were just some face coins. After 65, there were some foreign coins in there. I didn't assign any value to those because I didn't have any knowledge of if those foreign coins were worth a dime. So I think I put not applicable to the foreign coins. And then I'm clear to point out here that there was no collector's value considered in any of the coinage. Strictly precious metal value ascertained by the silver price at $65.42 a troy ounce.
If you did try to do collector's value, say Mr. Frey asked you and paid you that extra way back in 2016, what would that do to the number here?
It would go up considerably, but if Mr. Frey would have ever asked me that, I would say you need to go see a coin guy right now because I'm not going to even project a number for you.
And then the last section on the last page of that document, the jewelry and watch, $47,786.81. That was the one where it was harder because it's multiple components.
Yeah. And again, the goal part is there's a lot of math involved because it's identifying the purity on the scale, tested scale, multiply the purity by the weight on the scale times 3 gets me, if we were to go to a full retail, it might be 4.5 to get to retail to actually replace it. I was conservative at 3. And, but then the subjectivity can come in when it comes to, looking at the diamonds. and evaluating, ascribing some value to the diamonds or the gemstones. And that's where, you know, expertise comes in. And again, my bias is always toward grading it down because I'm in a business where I don't want to create an expectation that I can't meet. I'd rather a diamond quality be a little bit better than what I'm calling it, than, you know, calling it too much, which is, you know, unfortunately, it can be all too common in our industry where people just get a grading report and say, oh, this is a ESI 1 or whatever. And they're fudging on the color and clarity so that someone can misrepresent it and call it what it isn't to get more money for it. So I've tried to run an honest business. I believe that's one of the reasons why I'm in business today, 20 years later. Had the #1 rated jewelry store in the state of Wisconsin for small markets, #1 recommended because I've tried to be honest through the years and tried to be conservative in my valuations and not to inflate. That was my original purpose in helping Mr. Fry back in 2016 when I had the pieces in hand. The other was just kind of estimating and trying to do my best to provide something honest for the court in the far right column, but again, with the bias towards being conservative.
Okay. I have no other questions.
Before I have you ask questions, Mr. Stroud, I know you're probably going to ask this question, but I just want to know right off the top of my head while I'm thinking. Mr. Otto, do you charge a fee for your valuations?
I probably charged him something, I can't recall. It might have been in the realm of $100 back in 2016. Might have been more than that. You know, if it's just 5 or 10, 15 pieces that through the years, I've done that for free, just as a service. And I probably cut back on that a little bit because there just aren't people who do this much anymore. So if it's just a handful of pieces, I'll still do that at no charge. If it was something like this, I'd say, oh, that's gonna, you know, it's gonna take a little time. I might need to charge you $100 an hour. And you know, maybe Mr. Fry's case, something like this. It probably would have taken me 3 or 4 hours, but I probably only would have charged maybe a couple hundred at the most. Maybe he could verify that, but there was a charge originally, but no subsequent charges.
No subsequent after the fact in the other 3?
Not that I can remember. Maybe Mr. Fry remembers, but I don't believe so.
Okay.
There was no fee on the last set of numbers provided to the court.
All righty. Mr. Schmidt, any question off of my few questions?
No, Your Honor.
All right, Mr. Stroud.
I would just judge, we've been at it for about 2 hours. Does anyone need to take a break before we keep going?
I don't know if you need to take a break or you want to take a break, but we do have when I scheduled Mr. Nelson and Mr. Byers' case, I did inquire as to with the district attorney how long it may take. And that's why I was scheduled him at 2:30. So if you need a break and Ms. Honeycutt needs a break, then we can take a break and I can hear Mr. Nelson and Mr. Byers.
Sure.
If otherwise we can keep going.
I'm ready. I was asking for your court reporter, your clerk, or anybody that needs one, but
Really need to be.
yeah,
She needs to go.
yeah.
I thought I heard a little or sensed a little. So we're fine with that. I did inquire with my clerk if she needed a break. She does not. I don't know about my court reporter, but we can take a break right after Mr. Nelson because it'll take some time for Ms. Honeycutt to go to the jail to use the services and then to be brought back. Okay. Then we will briefly adjourn so you can go have a break. And when you come back, you are still under oath and come right back to the seat.
Certainly. Thank you,
Okay,
Your Honor.
thank you. When we are
Just
done.
make sure to leave all those items up there.
Okay.
Yes, I don't believe we need them or need that chair. So you're free to leave and have some water, use the restroom,
Thank you, Your Honor.
and then we'll come back.
A defendant walked into court expecting a simple hearing. Instead, a judge reviewed pages of alcohol monitoring violations and immediately issued a bench warrant. The case involved a woman already facing serious charges connected to a 4th alcohol-related offense. As part of her release conditions, she had been ordered to use a SoberLink monitoring device. The system required regular alcohol tests and was designed to ensure she remained sober while her case moved through the court system. But according to probation officials, things went terribly wrong. During the hearing, the probation officer presented a long list of alleged violations. The court was told that the defendant had recorded numerous positive alcohol tests over multiple days. Test after test reportedly showed alcohol consumption, and there were also instances where required tests were missed entirely. As the violations were read into the record, the judge's concern became obvious. The judge reviewed the documentation and wasted little time reaching a decision. After hearing the evidence, he formally found probable cause that the defendant had violated the conditions of her bond. The judge immediately revoked her release, forfeited her bond, and ordered a bench warrant for her arrest. He also directed court staff to contact the defense attorney and have both the attorney and defendant appear in court as soon as possible. Then came the line that summed up the situation perfectly. Looking over the repeated violations, the judge simply remarked, "Boy, this is not good." It was clear he viewed the allegations as serious and believed immediate action was necessary to protect the integrity of the court's orders. The hearing serves as a reminder that bond conditions are not suggestions. When a judge orders sobriety monitoring, compliance is expected. Failing to follow those conditions can result in revoked bond, arrest warrants, and an even more difficult road ahead in court. Now the defendant must return to court and explain the violations, while facing the possibility of stricter conditions or even jail. Question: if someone repeatedly violates alcohol monitoring conditions while out on bond, should judges automatically revoke their release? Like, comment, and subscribe for more. A judge believed a gun case was nothing more than an honest mistake, but that didn't mean there would be no consequences. The defendant appeared in court after being charged with illegally transporting firearms. At first glance, the case sounded serious. However, once the judge reviewed the facts, a very different picture emerged. The defendant had previously possessed a concealed pistol license, commonly known as a CPL, but it had expired. He explained that he had already completed the renewal course and even had the certificate in hand. The problem was that he never finished the final steps required to renew the license. Before he realized it, the permit had lapsed. The judge questioned him carefully about what happened. The defendant explained that he was preparing to leave town for several weeks and wanted to store his firearms safely while he was away. Rather than leaving them at home, he planned to place them inside a large gun safe at his brother's house. According to his statement, he was transporting the firearms for safekeeping because he had children at home and wanted the weapons secured while he traveled. After reviewing the report and hearing the explanation, the judge made it clear that he did not believe this was a case involving criminal intent. In fact, he openly stated that he thought the defendant had simply made an honest mistake, but the court still expected accountability. Instead of imposing jail time, the judge placed the defendant on 6 months of probation and ordered him to complete a handgun safety program, perform community service, and stay out of trouble.